Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Today, we are joined by Subhash Bhutoria, and we will be talking about the image rights in Indian law. As you know, we are in the season of the BRICS nations. We've previously spoken about Brazil and Russia, and it was imperative that we invite Subhash over to come and talk about India. Subhash is a seasoned IP and art lawyer, and before joining DSK Legal, Subhash was leading the IP and art law team in Luthra and Luthra Law Offices, India. In a career spanning over 14 years, Subhash has worked with leading lawyers and firms, including Lal and Sethi, Lakshmi Kumaran, and Sidran Attorneys, and had founded the IP and art law practice at the firm Kidra Legal. Besides his professional commitments, Subhash is a member of the International Trademark Association, the ADR Committee, and the European Community Trademark Association and IP Forum. He is also an arbitrator with the Court of Arbitration of Art, Netherlands, and also with the Hyderabad Arbitration Center. He's also the legal advisor to the International Delphi Council, and he's regularly invited by universities as well as business associations for sessions or guest lectures on intellectual property law, contracts law, and art law. Welcome, Subhash.
Thank you so much, Navalinda.
How are you doing today?
All well. It's bright and sunny, and now winter is setting in. So Delhi is a beautiful place to be in winters. So yeah, I'm enjoying. I'm in office today, probably the last working day before we set our foot into the new year and have our holidays. So wishing everyone a very happy new year. And yeah, I'm looking forward to this conversation.
Thank you so much for coming on the show. I know that in India, you guys are quite big on production, the movies and the like. And I know that broadcasting is quite an important feature of not just your culture, but also your commerce in India. So what I was interested to find out from you is, firstly, does Indian law have protection and special recognition for image rights?
Well, we do not have a sui generis law. We don't have a specific law per se, but being a common law country, our cases, our courts are wary of image rights. And again, when I say image right, it would include all sort of rights relating to a personality. So they're wary of these rights. And over the period of time, over so many years, with plethora of judgments, we have discussed in detail the celebrity rights, the personality rights, the privacy rights. All of them become part of your image right, if I can say the bouquet, in detail, and have a very global approach, how, it has been developed globally. So when we talk specifically in Indian context, the image rights and celebrity rights are very well developed through case laws, through judgments, but we do not have a specific law as such. We do have reference of similar rights in certain legislations, which includes IP legislation, which includes consumer legislations, includes your cyber law related statutes, and in fact, to the extent our constitution of India greatly deals with personality, which is very integral to life and personal liberty. So in totality, we have a comprehensive system for protecting image rights and personality in general.
So would you say that the main two fields that regulate image rights are IP combined with personality law?
Yes, so we recognize personality as a property. Now, that property is very complicated to say, because from legal aspect, because it is not a tangible or intangible property per se, but it's something integral to a human. It's more of a human right. So while everything comes down from the law of the land, which is the constitution, which says that if you are a human, if you are a citizen of India, then you have certain fundamental rights, which includes your right to life, your right to personal liberty, your right to occupation, all these different fundamental rights. These are basic rights that you have. Now, when these statutes are created, when they are enforced, then all these fundamental rights are also taken into consideration. So specifically, when I talk about publicity or personality right or image rights, because you have a right to privacy as a fundamental right, you have a right to life as a personal fundamental right, and you have a right to occupation as a fundamental right. These statutes take that into consideration and say, yes, look, if you have a personality, if you are an endorser, if you are an influencer, you have certain rights, you have certain liabilities. If you have a name, you have a likeness, you have certain, you know, signature or a brand value, then it is recognized as something more like a trademark law. If you have certain, say, you have a photograph, your image is known to people, you have certain way of, the way you look, the way you dress up, all those things, then it can also be part of the copyright. And if you're a performer, then there is a specific section, a chapter in the copyright law which talks about performers' right. So in different context, because we bifurcate image rights into different components, we identify each component to say it's not just a whole bunch of, or a broader image right, but we bifurcate it to say if it's a celebrity right you're talking about, if it's a personality right you're talking about, if it's your performers right you're talking about, then you have to deal with all these different chapters, different provisions of law.
So, speaking about this differentiation, if it's a celebrity right or personality right and so forth, when you're dealing with influencers, because social media has given a rise to influencers, where do you place them? Do they fall under celebrity rights if they need protection over their image, or do you follow personality rights or copyright? I mean, there are a lot of legal issues can come up in influencer countries, especially when they're vague and not specific about who owns the content that is used by the influencer to lure the audience on social media to be interested in a particular brand or service. So where exactly do you place influencers?
So we have to see from the context of, there are two aspects to it. Of course, an influencer is an influencer because that person is well known. That person, there's a huge following that person has, maybe on social media or otherwise. And influencers over a period of time, they have become celebrities. They have a celebrity status. They are as good as a Bollywood actor or a sportsman. And recently we are seeing in FIFA, Salt Bay is there, and there are so much controversies around it. So we are seeing that influencers are akin to celebrities, and their treatment is also celebrity. But yes, when we look at their personality vis-a-vis, when we look at the way they endorse or influence or publicize, there are two different aspects. Looking at their celebrity right or personality right is more of a human right, which is inalienable in a way. But when you're looking at them as an endorser, then there is a liability. Now, in Indian context, when I'm talking specifically about influencers, it is not just about uh, their inherent presence or visibility or right, but also how they promote the product or service for which they are endorsing. That is very important for us to understand here, because influencers, they play uh, both ways. They are celebrities who are endorsing, who are marketers, who are advertisers, right? So when they're talking about a celebrity right, say somebody has created a caricature of a influencer, then they are talking about celebrity rights. But when they're talking about a product or service which they are endorsing, then we are purely looking at their influencer marketing rights, whatever. So in case of influencers, uh, and because the IP law, especially if you're talking about trademarks law, which is close to your, your consumers or your public at large, uh, it goes hand in hand with the consumer protection laws in India. And that's why, while IP laws give some exclusivity, give some rights to you, the consumer protection law binds an influencer to say that, look, you cannot just do anything and everything under the sky. You have to be cautious of what you're promoting, what you're advertising. If that good or that service is false, it is substandard, it is deficient, uh, and you have given a misleading statement in the to the public at large, then you are held liable, and held liable to the extent that you have to pay a huge sum as a compensation, as a penalty, and you can even be held criminally liable. So now there is a liability associated with influencer or any celebrity who is marketing certain products or services. So this is an important aspect, but because when we are doing agreements, when we are doing contracts, then these aspects need to be inculcated so that the liability is reduced, it is mitigated. So this is how we differentiate the two different legal or legalities associated with influencers: the
So,
celebrity rights and the marketing rights.
so when it comes to the marketing regulation, with the specific forum that consumers have to approach, is there an independent advertising regulatory body like you have in many jurisdictions, or do your consumers have to follow a court process or a different type of consumer tribunal if they want to lay a
Yes.
complaint about an influencer's advertising approach?
Yes. So we have a specific consumer redressal system where we have forums from the lowest district level to the highest national level, based on the jurisdiction that you approach the forum, which is a judicial, quasi-judicial body. That forum uh, resolves the disputes between consumer, the complainant, and the advertiser or the the manufacturer or the service provider. Because primarily and traditionally, how consumer protection is seen as, if you are dealing with a defective product or a deficient service, then you would approach the consumer. But now, after 2019, the law has been amended to not only include the manufacturer or the service provider, but also the endorser. So if you are an advertiser of a defective product or a deficient service, then you are also liable, and you can also be dragged into that forum. That is one thing. Then we also have not for profit council, which is quite infamous in India. It's called Advertising Standard Council of India, which has a whole set of guidelines. Now these guidelines are broad guidelines, and based on which they uh, scrutinize each advertisement. And if there are influencers or endorsers in these advertisements, it generally happens in India. You would see Amitabh Bachchan or Sachin Tendulkar or Dhoni or all these celebrities endorsing certain products. So they have specific guidelines to say that a third party cannot use the celebrity names and likeness, or if you are doing, you cannot give a misleading statement. So but these are recommendations. This is an organization just like UN or any international organization, where you just give recommendations. You cannot have a binding force. You don't have a binding force. The binding force comes from Consumer Protection Act, and it also comes from sui generis IP laws, which we have, like Copyright Act. We have Trademarks Act, and we also follow in IT Act we have identity theft. So that's a criminal liability. Then you can also, because we are a common law country, so you can always claim your remedies under passing off or misappropriation of your personality rights.
Wow. It's quite unique how the endorser is also captured in your consumer protection
Yeah.
laws, which is a bit different from how our advertising regulatory board approaches advertising issues relating to influencers. That's an interesting angle. But you mentioned copyright quite often in our session so far. So I want to take you there to the copyright issues, but specifically the intersection between copyright, artificial intelligence, and image rights, because we so often see deepfakes, for example, being created, obviously with some reliance on people's real images. And I've always had a sort of like a twofold question about, firstly, the company that uses the artificial intelligence to create that deepfake, can they actually acquire copyright over what they've created if they relied on someone else's image? Especially because that would be protected by their personality rights. It seems to me that there's a clash between the two interests here, the copyright interest that would vest in whatever artistic work and the personality rights that would vest in the person whose image is being used to create the deep fake. But also at the same time, I tend to wonder if whether there is even a strong claim against such companies where you find so many people on social media uploading their selfies and their images and so forth. To what extent have we sort of sold away or given away our rights to our images specifically to these companies, especially those who do research on AI and so forth? Because there's always that research defense that can kick in as well. What are your views on this particular issue?
See, there are multiple issues arising from such usage. So let's simplify it to say that if you're uploading your photograph and there's an entity which collects all these photographs of different users and create its own work. Now, traditionally, and if we look at purely from legal perspective and look at it from copyright infringement perspective, say, where it is required that the new work or the work which is claimed to be the infringing work is substantially similar, is a slavish imitation of the existing work, then it's an infringement. So if you take my photograph and you pixelate it, you mix it with some landscape, you put it somewhere and you just use one eye out of the whole photograph, say for example, maybe it's not substantial imitation of my existing photograph. So traditionally, even if we are changing the medium, we are changing the way the new work is created, be it created by AI or machine learning or whatever, when it comes to action, an actionable claim or a cause of action arising because of creation of that work, and the court has to look at it from a copyright infringement perspective, it will always see whether the new work is a slavish imitation of an existing work, right? So if it does not imitate or substantially look similar, and there is enough judgment, skill, and labor involved in creation of that work, then that work is a new work, and it will also have a copyright, protection over it. You can also claim the exclusivity. So generally, that is how we'll apply the test in case of any medium or any way the new work is created. Now, it can be an issue that if you you take my image and mix it with something which is derogatory, which is against the public order, you put me in a in a shape or form which I do not agree with, then that will basically be an issue of libel or defamation. It can be issue of identity theft. It can be issue of misappropriation of my personality rights. So the other statutes, be it the penal codes, be it the Information Technology Act, be it the common law remedies, they will kick in at that instance. So you have to decide when something like this happens, you as a complainant has to decide what is the right recourse. It may not be that every time you approach the copyright or the IP courts for such kind of matter, you might have to take a different aspect or different way of of resolving your such issues.
I think this is what makes the image rights issue so complex and probably very difficult to remedy, because if, for example, someone is advised by a lawyer who advises them to go the copyright route when
Yeah.
perhaps they could find a stronger grounds or remedy under the penal codes, then it doesn't necessarily mean that a person does not have should not have recourse, but it just means that your lawyer probably didn't advise you properly.
Yeah, it's at the end of the day, it is about effectiveness. If the effective remedy is not with the copyright law, but with Indian Penal Code or any penal code for that matter, then you would rather explore that instead of going to an IP court, right?
Wow. I just get the sense of there's a whole broad possibility of injustice, even where someone may have a legitimate claim. But because of the various options that one has to be sure about which route they choose, things could go wrong simply because of what you choose, which is a very big injustice for consumers out there. But I wanted to move into the issue of taxation, especially now that we've just come out of the sports season with the World Cup. We often find that sports players in particular face a lot of challenges with taxation of proceeds that they get from image rights exploitation. Can you maybe share what approach India uses to tax image rights profits?
Well, there's no specific, provision for image right as such. If I talk in the context of influencers or celebrities who are endorsing certain product, they're providing their service based on their personality, based on their following, fan base, whatever. So they are providing a service. So whenever in India, it is very simple that way. Whenever you are providing any product or any service and there's an income which is accrued on the basis of your profession or business, it is construed as your income and there's a tax levied on that income. Now when you're providing a service, generally it is a tax which is deducted at source. So whenever you are getting paid, there will be a deduction made by the person who has engaged you for that service. So there's a TDS which is deducted. So that is one aspect. Now, recently, there has been some amendment in the tax law where it says that if an influencer is given a product which it is going to promote or market, and that product is retained by the influencer. So if you give me an Apple phone and I retain that Apple phone with me, then if it is above 20,000 INR, then there's a tax which is levied on it. So now they've realized, the Indian tax authorities and the policymakers have realized that influencers are day in day out they're traveling or they are using these products and using these services for at no cost. But this is something which is part of their income. Otherwise, they would have bought these services or bought these products. So they are also taxing these products and services which the influencers retain with themselves. So there's a bit of a change in the law. Otherwise, mostly it is a simple income tax regime that follows and service tax regime which follows for influencers and celebrities.
So it ideally rests on the influencer to declare the items that they receive.
Yes.
Interesting. Interesting. So, we've spoken about quite a number of issues. We've spoken about copyright, personality rights, and now tax. Based on what we've covered, what are the 2 tips or pieces of advice, 1 or 2 at least, that you would give to upcoming influencers or even people who, they're not aware that they're becoming influencers, but they're well on their way to being well known enough to be able to exploit their personality? What would you advise them, specifically in the context of Indian law, what to look out for, what to be careful about, especially when they enter into influencer contracts and so forth?
So, well, a couple of things. I don't know if it will be 2 or 3, but a couple of crucial things that they need to consider. One is from the IP perspective, that because the Indian copyright law says that whoever involves or engages a photographer for a consideration, that person who is engaging that photographer has a right, the first owner. So if an influencer is getting clicked by a photographer at behest of someone else, that someone else would have the rights. So you need to have a contract where it clearly is mentioned that you can use my photographs in such manner, you cannot use my photographs for anything else. You can restrict all that thing, you can have the proper covenants in that contract. One is that from your image right, from identifying and protecting your rights. Then of course, because the laws are such now that you as an influencer cannot give misleading or false statements. So you have to undergo and do your own due diligence, which is also required under law. So the law says that if you have done your due diligence, if you have been cautious about what you are promoting, and you are aware that this product or service is correct, it is not substandard, it is of proper quality, and everything is in order, then your liability is significantly reduced. So if you want to reduce your liability arising from influencer marketing at your own end, you need to do a due diligence of every product or service that you are endorsing or you're promoting, and have a protocol embedded in your contract to say that you will give me the product in certain period of time. I'll do a due diligence on that product, or my team will inspect the product or whatever, and then once I confirm, only then we will start the process, so that there is clear demarcation, and there's a clear evidence that you have done your due diligence, and only then you have done this marketing.
Wow, that's really good advice. I think for everyone, not just influencers, even celebrities who are in brand endorsements and so forth. I think that's quite an important thing to remember. So Subhash, last but not least, if anyone wants to get in touch with you about this topic or any other IP and art law related issues in India, how can they contact you, either on LinkedIn or any other social media platform? How can they reach you?
I'm also an influencer in that way. And you're helping me out. So I'm always happy to help. And it's been a wonderful time practicing law in India. We are a great country with amazing laws and extremely proactive enforcement. So if you have any issues, not just issues, but you just want to talk about it, discuss it, I'm always happy to help. I'm available through LinkedIn. I leave the WhatsApp number with you. I'll leave my email ID. You already have my email ID, so you can share that, which is subhash.bhutoria@bsklegal.com. And I'm based out of Delhi. If anyone's traveling anytime in Delhi, please let me know. Would be happy to catch up.
Indeed. Thank you so much, Subhash. It was lovely having a chat with you.
Likewise. Thank you so much.
Remember to control your image rights.
This podcast is based on research supported by the National Research Foundation of South Africa, grant number 121-887. But the views and opinions expressed in this podcast do not represent the National Research Foundation, its management and governmental structures.